David Soble, and I'm a Michigan real estate and finance attorney. For almost 30 years now, I've dealt with mortgage and financial disputes between borrowers and lenders. And years ago, the lending environment was very easy to maneuver, and there were very few, if any, federal regulations that gave the debtor any rights against a lending institution or a loan broker. However, ever since the great financial crisis of 2008, things have really changed. So federal and state laws regulating lending have actually more teeth or penalties in them. And so when it comes also to enforcement, federal and state and also consumer right agencies are much more active and vigilant against bad actors in the lending industry. But one thing has remained constant, in my 30 years. So there are changes since 2008. But the one thing that's been remaining constant since I've been a lawyer is that debtors do still have a limited amount of time to challenge what they may perceive as lender misconduct or even lender abuse. So generally speaking, if you, as a debtor or a borrower, wish to legally challenge a loan agreement for whatever reason, a debtor only has 5 years from the date of a loan closing to actually bring a lawsuit based upon loan documentation or the actual loan process. So if you're going to challenge the loan process, you have 5 years from the date of closing. And when it comes to a mortgage foreclosure, federal law is clear that a homeowner has to bring any action, any legal lawsuit asserting a defective foreclosure or a defective foreclosure process or a foreclosure defense within a homeowner's redemption period. So most often the homeowner's redemption period is 6 months from the date of a foreclosure sale. And courts have ruled that once a redemption period has expired, there's no, you've extinguished the mortgage. So there's actually no mortgage contract left for a homeowner or now a former homeowner to have standing, which is the right to actually bring a lawsuit. So it's 5 years after a foreclosure. It's 6 months after a foreclosure. 5 years after you close a loan. Finally, when it comes to business loan agreements or a promissory note, a lender only has 6 years to bring an action against a debtor for non-payment. And the 6 years is calculated from the last day in which a lender accelerates or calls the entire balance on a note due and payable. After that, the lender is barred from bringing any action against a debtor. So what you need to know as a debtor or a borrower is that, I currently have a client who's being sued by a lending institution. And in 2010, a lawsuit was brought against them to collect on my client's business loan. And that action was dismissed without prejudice, which basically means that, somebody could bring the action again concerning the same facts and the law again in the future. But no payments from 2010 were made since the lawsuit was dismissed. And so the lender refiled their suit in 2018. So 6 years have passed, obviously, from 2010 to 2018. So for all intent and purposes, the lender's legally blocked from bringing a lawsuit against the client. So loan agreements, mortgage and financial contracts, they're all complicated legal instruments. And time bars for bringing a legal action are often the easiest defense for an attorney to raise. But I'm going to share with you that there are numerous legal defenses and legal theories that serious legal practitioners, we invoke on behalf of our clients. And if your legal and financial situation is critical, you actually need to contact an attorney for assistance. No other professional can be of assistance. Not a realtor, not a mortgage loan officer, not even your neighbor. So get to a contract attorney right away, somebody who specializes in contracts and real estate and finance. That's who you need to speak with. I'm David Soble. I can be reached at 888-789-1715.